Can the same case be filed twice? Can a person be punished twice for the same offense? Why do courts favor finality of cases? To know the answer, stay till the end of the video. Dear friends, you are watching easy learning site Mr. Ask Me Anything. In this video series, I am going to simplify the doctrine of Res Judicata to answer the questions. Now pay attention. Meaning of Res Judicata. Res means thing. Judicata means already decided. So Res Judicata means a matter already decided by a court. The provision of section 11 of CPC 1908 deals about the doctrine of Res Judicata. What does section 11 of CPC 1908 say? A civil court cannot try a case or part of a case again if the same issue was already decided in a previous suit between the same parties or their representatives in a court that was competent to decide it, and the matter was finally decided in that case. Key condition for Res Judicata to apply. Number 1, there must be two suits or issue in which subject matter is the same. Number 2, the previous suit must have been decided by the competent court and the subsequent suit must be pending. Number 3, the issues in the previous suit and the subsequent suits must be directly and substantially the same, meaning the issue was directly connected to the main dispute and seriously important to the outcome of the case. For example, if two people fight over ownership of land, then who owns the land is directly and substantially in issue. But something like who paid the electricity bill is not, unless it affects the ownership. Number 4, party must be the same in both the suits and litigating under the same title. Number 5, the court which decided the previous suit must be competent to try the subsequent suit also. Doctrine of Res Judicata under section 11 of Civil Procedure Code 1908 also contains explanations which are very important. Let us come to the explanations. Explanation number 1 says, former suit means the case that was decided earlier even if it was filed later. Explanation number 2 says the court must be legally competent even if the decision could be appealed. Even if someone could appeal that decision, the issue is still considered finally decided for Res Judicata. Explanation number 3 says the issue must have been raised by one party and denied or admitted by the other. Explanation number 4 says if you could and should have raised an issue earlier but did not, it is still considered decided. Explanation number 5 says if a relief was asked in the earlier case but not granted in the judgment, it is treated as refused. Explanation number 6, that is common right litigation, says if someone goes to court honestly, that is bona fide, to protect a public or shared right, then the decision will also apply to others who shares the same right even if they were not directly part of the case. Example, one villager sues to protect a village water source, then all villagers are bound by the result. Explanation 7 applies to execution proceedings. It says that Res Judicata also applies to executions of decree, not just to regular suits, original suits, meaning if a court already decided something during execution, it cannot be raised again. Example, a person wins a civil case and gets a money decree, say rupees 5 lakh. He files an execution petition to recover the money by attaching the judgment debtor's property. The court rejects the request to attach a particular property, saying that property is exempt from attachment. Now, he cannot file another execution petition later asking for the same property to be attached again, because that issue, whether the property can be attached, was already decided in the earlier execution case. Explanation number 8, lower court's decision still counts, which means if a court had limited jurisdictions but was competent to decide the issue at that time and it did decide the issue, then res judicata applies, despite today that court cannot try the new suit due to the change of limited jurisdiction. The court which decide the former suit must have been either a court of exclusive jurisdictions like revenue courts, land acquisition court, administrative court, etc., or a court of limited jurisdictions like courts other than ordinary civil courts like revenue courts, land acquisition courts, insolvency courts, or a court of concurrent jurisdictions, that is, concurrent as regards the pecuniary limit as well as the subject matter. Let us come to the example. Suppose in 2015, a court had pecuniary jurisdictions up to rupees 1 lakh, which decided a case involving rupees 95,000. In 2025, a similar suit involving rupees 3 lakh is filed. The earlier court now cannot try it. Still, the earlier decision will operate as res judicata because at that time the court had the jurisdictions to decide, which was heard and finally decided the issue. In short, former court with the above stated jurisdictions become incompetent to try the subsequent suit due to the growing of pecuniary limit jurisdictions and change of subject matter jurisdiction. Even then, still doctrine of res judicata is applicable. However, if court become incompetent due to the reasons other than the reasons as stated above, then res judicata is not applicable. Thus, it requires test to examine whether the second suit could have been decided by the former court. If the answer to the question is yes, that is affirmative, the decision will operate as res judicata. But if the reply is no, that is negative, res judicata has no applications. Now let us look to the underlying principles. That is, the doctrine of res judicata is based on the following maxims given below. Number 1, res judicata pro veritate accipitur, which means a matter adjudicated is taken as a truth. That is, once a competent court has decided an issue, it is accepted as the final truth and cannot be questioned again in another court between the same parties. Number 2, nemo debit bis vexere pro una id idem causa. That means no one should be vexed or harassed twice for the same cause. That is, a person should not be dragged into litigation again on the same matter once it is finally decided. Number 3, interest republicae ut sit finis litium. It is in the interest of the state that there should be an end to litigation. That is, law favors finality in dispute, unless litigation causes instability and misuse of the justice system. Number 4, ex turpi causa non uritur exio. Sometimes this is cited in the doctrine of res judicata, which means no actions arises from a dishonorable cause. That is, party cannot seek relief based on a matter that has been already decided unfairly or fraudulently. Thank you for watching Mr. Ask Me Anything. Please do like, share, comment and subscribe if you like new video on new topic. For now, I'm signing out. Till then, take care.